So we are going to discuss the relationship between international law and municipal law. Now, as far as international law is concerned, all we know that it primarily regulates the relationship between the states, while the municipal law or the national law, it regulates the relationship between an individual and his country, that is the state. So both the laws seems to be very different from each other. Still, there are divergent views about the relationship which is shared by international law with the municipal law, and these divergent views have been expressed in the form of different theories, and the state practices are also varied between the states, and therefore with the help of certain theories and certain state practices we will try to understand what is the exact relationship shared by international law with the municipal law. And the question we have to discuss is also that whether international law prevails over the municipal law or it is vice versa. And accordingly, we will be discussing this particular topic. So, firstly, let us come to theories which try to explain the relationship between these two laws, that is, international law and municipal law. There are 5 prominent theories which try to explain the relationship of international law with municipal law. And these theories include monism, dualism, specific adoption, transformation, and delegation. So total 5 theories have been advocated. Now the first theory is known as monism. Now the word monism is composed of 2 words, mono and ism, and it stands for single philosophy. So according to the protagonists who have supported this theory, the international law and municipal law, they are one and same, and they represent unity. That is, they are the part of the same scheme, and they are nothing but the same philosophy. So both the subjects, international law and municipal law, they are not different from each other. Rather, there is a similarity between the 2 subjects, and both the subjects ultimately deal with the individuals. Now, as we all know, international law deals with the relationship between the states, but a state cannot come into existence without individuals. And so far as the municipal law is concerned, it regulates the relationship between a state and the individual. So both international law and municipal law have individual at their root, and since individual is at the root of both the subjects, that's why both of them are one and the same philosophy, and there is no dichotomy, and both of them are one and same, and they belong to the same scheme, or they belong to the same system. So this theory is known as the theory of monism. But as far as this particular theory, that is theory of monism, is concerned, it is not always acceptable, because we all know that both the subjects are inherently different, and that's why this theory may not be acceptable in all the situations. Now the second theory which is advocated in this regard is known as the dualism. Dualism, it is again composed of 2 words, dual plus ism, and dual plus ism, it stands for 2 different philosophies. So international law and the municipal law, they differ from each other, and they represent entirely different subjects or different fields of knowledge, or they are different philosophies. Now if we go to the differences between international law and municipal law, or the points of distinction between them, then we come to know that their sources are different. The source of international law is the common will of the state, while the source of the municipal law is the will of a particular state. Similarly, as far as the international law is concerned, its main sources are international custom and international treaties, while the main sources of the municipal law include the statute law and judicial decisions. Then as far as the operation of both the laws is concerned, it is again different, because the international law, it operates between the states. So it is the law which operates between the states, while municipal law, it operates upon the individuals, and that's why as far as the operation is concerned, both the laws differ from each other. Then another point of distinction between international law and the municipal law, according to dualism, one more difference between them is the subjects of international law and municipal law. That is, the main subjects of international law happen to be the states, while the main subjects of municipal law happen to be individual. And one more point of distinction between them is the substance of these two laws. That is, they differ in their substance also. To know that, in case of international law, the international law, it operates between the states and is not above the states, while the municipal law or the national law is the law of the sovereign and it operates over the individuals. So they are diametrically different from each other, and therefore the advocates of dualism, they have said that both the subjects, international law and municipal law, they differ from each other. Now, as far as the dualism theory is concerned, dualism theory has been well received in international law, and many scholars are of the opinion that it truly explains the exact relationship between international law and municipal law. That is, they are entirely different branches of law and they operate in different spheres, and that's why they are totally different from one another. Now, one more theory is there, and that is known as specific adoption theory. Now, specific adoption theory is a kind of offshoot of the theory of dualism. Now, specific adoption theory believes that the provisions of international law cannot directly become the part of the municipal law unless and until there is specific adoption made. So in absence of the specific adoption, the provisions of international law and international treaties especially, they cannot become the part of the municipal law according to specific adoption theory. And what is meant by specific adoption? That is, so whatever is the subject matter of the international treaty, the particular state has to enact a legislation incorporating the provisions of that treaty into the legislation. Then it will amount to specific adoption. Now, as far as Indian Constitution is concerned, Article 253 of our Constitution, it makes a provision for specific adoption of international treaties into the Indian law. So international treaty does not become automatically or ipso facto the part of the municipal law, but it requires certain action on the part of the legislature, and that action is nothing but the passage of the legislation on that topic. Then only international treaty can become the part of the municipal law. So this particular theory is known as the specific adoption theory, and it is a kind of offshoot of theory of dualism. Now, one more theory is there, and it is very similar to specific adoption theory, and it is known as transformation theory. Now, so far as transformation theory is concerned, this theory says that international law is largely in the form of international treaty, and international treaty, it is a kind of promise given by the states to one another. That is, they will abide by certain rules given in that treaty. So international law is nothing but a kind of promise, and that particular promise is given by the states to each other. Now, on the other hand, if we see municipal law is a kind of command of the sovereign given to the subjects. So just like Austin has said that law is a command of the sovereign, in that particular way we can say that municipal law is a kind of command given by the sovereign authority or determinate sovereign authority, and that command is absolutely binding upon the citizens. And if they commit violation of that command, then it will be followed by sanction or punishment. So this is known as the command theory. So municipal law is based upon the command, while the international law, it is based upon the promise. And when the promise is transformed into command, we can say that international law is transformed into the municipal law. So each and every constitution has got certain mechanism for converting the promise at international level into the command at municipal level. And when such law is enacted, then that amounts to transformation of international law into the municipal law. So for example, when India signs an international treaty like anti-hijacking treaty, and when there is a legislation made by the Parliament of India prohibiting the act of hijacking and providing punishment for that offense, then there will be transformation of international law into the municipal law by certain constitutional mechanism provided in the constitution. So this is the theory known as the transformation theory, because there is a transformation of international law into the municipal law, and promise is converted, or the promise is transformed into a command, and by way of such conversion or transformation, the international law becomes the part of the municipal law. So this theory is known as the transformation theory. And one more theory is there known as the delegation theory. Now this theory believes that international law delegates the power to incorporate the provisions of international treaty to each and every state into its constitution, and when that power is exercised by the state, then that is known as the delegation theory. So delegation is done by international law in favor of municipal law, and through that delegation international treaty can become the part of the municipal law. So in this manner, all the five theories, namely monism, dualism, specific adoption, transformation and delegation theory, they try to explain the relationship between international law and municipal law. Still, none of these theories is perfect, and that's why we have to look into some of the state practices as well along with the theories. Now, as far as the state practices are concerned, three main state practices are there. Firstly, the state practice of USA, then state practice of UK, and lastly the state practice which is followed in India. So these are the prominent state practices. Now firstly we'll see what is the practice which is followed in USA. Now as far as the customary international law is concerned, as said aptly by Justice Gray in Packet Habana case, which was decided in 1900, in that case Justice Gray observed, and I quote, "International law is part of our law and must be ascertained and administered by the courts of justice of appropriate jurisdiction as often as questions of right depending upon it are duly presented for their determination. For this purpose, where there is no treaty and no controlling executive or legislative act or judicial decision, resort must be had to the customs and usages of civilized nations." In this case, the court found and applied a customary rule of international law exempting coastal fishing vessels from capture as prize of war. So, as far as the customary international law is concerned, the customary international law is considered to be the part of the US law or the part of the American law, as said by Justice Gray. Now then, as far as the treaties are concerned, in USA, the treaties are classified as self-executing and non-self-executing. The self-executing treaties execute themselves without requiring any action from the American Congress. But the treaties which are essentially non-self-executing treaties, they require certain action on the part of the American Congress. So two types of treaties are mentioned in the United States, and these treaties, they include the self-executing and non-self-executing treaties. Now as far as the case law is concerned in USA, in UN Headquarters Agreement case of the year 1988, International Court of Justice has said that harmonious construction rules shall be adopted whenever the court is considering international treaty, and when that treaty is to be considered, then the international treaty will not override the municipal law, that is the American law. So the municipal law and the treaty provisions, if they are inconsistent, then it is advisable to bring about a harmonious construction between them, because the Congress never intend to give precedence or to provide for supremacy of the US law over the international law, and that's why this particular procedure has been prescribed in United States in various case laws. Now then let us come to the practice which is followed in another country, that is in United Kingdom. So let us come to the British practice or the practice in UK. Now as far as the practice in UK is concerned, the British courts have made distinction between international custom and international treaties. Now as far as the customary rules of international law are concerned, the rule relating to customary international law or international custom has been summed up by Blackstone in following words, and I quote: "The law of nations, wherever any question arises which is properly the object of its jurisdiction, is here adopted in its full extent by the common law, and it is held to be a part of the law of the land." So as far as the customary international law is concerned, it is considered to be the part of the British law itself. So this particular doctrine, it says that the customary international law, it becomes the part of the British law in an automatic way or in automatic manner. Now as far as the decisions in England are concerned, the decisions however show that there is no automatic conversion of international custom into the British law. That is, the practice actually shows that there should be some kind of incorporation of the international custom or the customary rules into the British law, and then only it can become the part of the British law. Now the case on the point is Chung Chi Cheng versus R. Now in this case, the Privy Council observed the court acknowledged the existence of a body of rules which nations accept among themselves. On any judicial issue, they seek to ascertain what the relevant rule is, and having found it, they will treat it as incorporated into the domestic law so far as it is not inconsistent with rule enacted by statutes or finally declared by the tribunals. Now Lord Denning in Trendex Trading Corporation versus Central Bank of Nigeria, which was decided in 1977 in England, in that case Lord Denning MR, he has expressed the opinion that as between transformation and incorporation doctrines, the doctrine of incorporation is correct. So he has given more weightage to the doctrine of incorporation. Now then let us come to the practice in UK so far as the treaties are concerned. Now the British practice regarding the treaties is different from the practice applicable in case of custom. Now as far as the practice relating to international treaties are concerned, generally the practice is that the treaties are classified into certain types. For example, treaties expressly made subject to ratification by the British Parliament. Then treaties involving an alteration of English law of taxation, and treaties affecting the private rights of British citizens. So if some treaties are there which require certain burden to be imposed or certain private rights to be affected, then in that case the Ponsonby rule is made applicable. That is, the ratification is necessary from the British Parliament, and by that way the international treaty can become the part of the British law. So that is the practice followed in England. Now let us come to India. As far as Indian practice is concerned, there is no clear-cut mention about the international custom, but there is a important topic in Indian Constitution known as fundamental duties. And one of the duties, it says that the state shall endeavor to promote the respect for international law. And in Article 253, there is a clear-cut mention of international treaties. And therefore, we can assume that the expression international law used in 51C, that particular important provision is applicable so far as the international customs are concerned. So this particular Article 51C, it deals with the international custom. And as far as the international treaties are concerned, they usually become the part of the Indian law only by way of specific adoption. But of late, we can see that the requirement of specific adoption is also not there, or it has been relaxed to a certain extent, because we find that in certain cases like Vishaka case, the international treaty known as CEDAW, that is the Convention on All Forms of Discrimination Against Women, certain provisions of that particular international treaty on the topic of prevention of sexual harassment at workplace, they have been adopted as a part of Indian law. And it was suggested by the Supreme Court of India that on the basis of CEDAW, the guidelines which are being given by the Supreme Court of India, they will remain the applicable law on the topic of prevention of sexual harassment till the suitable law is enacted by the Indian Parliament. And that suitable law was enacted in the year 2013. Until that particular point of time, Vishaka guidelines remain the law. So here, international treaty in the form of CEDAW, it became the part of the Indian law even without specific adoption. So of late, the specific adoption has also been relaxed. Now, one more example we can take is that of the case of Nilavati Behera versus State of Orissa, wherein it was held that for custodial death, the next of the kins are entitled to compensation. And this was based upon the Universal Declaration of Human Rights. So without waiting for specific adoption, the international treaty can be read into the Indian law, provided it is not against the Constitution of India. So this is about the relationship which is shared by international law with municipal law, and it appears that as far as possible, harmonious construction rule is to be applied, and the municipal law is generally given supremacy over the international law. That is, international law can become the part of the municipal law only if it does not go against the constitution of the country. And that's why municipal law has got certain extent of supremacy over the international law. And in some cases, the specific adoption is necessary in order to make international treaty as a part of the domestic law. So with that, we come to the end of this lecture relating to the relationship between international law and the municipal law.